Hello, everyone. Thank you for tuning in. We are going to just give everyone a couple of minutes to get on, and then we will go ahead and jump right into the content. Please feel free to share this live out if you know someone who is building a business, has a business, building a brand, creating a brand, thinking of having or creating a brand, and they can use this information. Today,
Hello,
we are
everyone.
talking
Tuning in.
trademark basics, copyright basics, and ways to protect your brand in your business. So, again, thank you all for tuning in. We'll get started in about 1 minute. And if you know someone that can use this information, please go ahead and share it. All right, we're going to go ahead and get started. Let me just shift the camera here. There we are. Hi, everyone. Thank you for tuning in to our live collective conversation. Those of you who may be new around these parts, I'm Marissa V. Grayson. I am the founder and managing attorney of the Collective Legal and Crisis Management Firm. We are a firm that basically handles all legal matters. And we are just in this game right now to be a resource to the community, to help out the culture, to share as much information as possible. We know a lot of people are quarantining right now. We know a lot of people are building businesses right now, working on their brands right now. And we just wanted to be able to make sure that we take some time to give back, to be a resource to all of you, and to make sure that we can answer any questions so that you can make smart business moves, smart life moves. We've done a lot of different conversations. So again, thank you for tuning in. Thank you for joining me. Again, I'm Marissa V. Grayson. And with me today, I have my co-counsel, one of our lead attorneys of the Central Florida Division. Her name is Shannon N. Davis. Shannon was hand selected to be a part of the Collective Legal and Crisis Management Firm because of her utmost diligence. She serves clients in our Central Florida Division. I already said that. And as an attorney and counselor and advocate for the protection of people's rights, she is uniquely positioned conduit of change and focused on the needs and interests of her clients. She also has her own private practice in Central Florida as well. Her motto is maximizing your voice, and that is the goal of all of the work that she does. So she also works on trademarks within her firm and ours as well. So welcome, Shannon. Thank you for joining in on this conversation.
Thank you.
Of course. So for those of you who have not yet tuned into a collective conversation, let me just give you a little bit of insight on how this works. Yes, we are attorneys. Yes, we have a team of professionals. Yes, when we're in the courtroom or dealing with business matters, we're super buttoned up like most lawyers are, right? But for these conversations are very informal. They are meant to be informational. We are just here having a conversation between the two of us. And essentially, you all are invited to participate and to be a part. So if you have any questions, make sure that you drop them in the comments section. I know some of you did send me some questions ahead of time, so we'll get to those as well. And essentially, it's just a chat. So consider us your sisters-in-law. And we're just talking about trademarks and copyrights and protecting your brand. And again, if you have questions, go ahead and drop them in the comments. If you know someone who can use this information, please feel free to share this live with your network. And let's just go ahead and get started. So firstly, let's just talk about intellectual property in general, right? Because at some point, intellectual property is going to be important to pretty much anyone who has conducted a business, is conducting a business, is running a brand, whether it's related to your business name, a slogan that you use on a regular basis as it relates to your business, your your logos, things of that nature, any original work that you create, all of that stuff is part of your actual brand and your business, right? So at some point, intellectual property and protecting your intellectual property is going to be extremely important. One thing that we find on a regular basis is that people are shysty. People are quick to copy others. They will literally copy and paste your entire website and post it as if it's their own, just change a few colors and things of that nature. People copy people's business ideas and all kind of stuff, right? Business names, slogans, they start using them. So we just want to make sure that if you're using something on a regular basis and it has become a part of your business or your brand, you know how to protect it so that other people aren't able to capitalize on something that was originally created by you. So, Shannon, you want to chime in there?
Yeah, I just think it's really important. And I mean, Marissa said a lot of it, but oftentimes we don't think that we need to formally protect our intellectual property. Intellectual property and all of it that we're going to explain, they're complex, but there are simple ways to sort of break down what it is. Intellectual property is a property of your mind. It's your ideas, your inventions, those things that you create. And oftentimes we think, well, I created it, so there's nothing else that I need to do. As long as I let everyone know that I created it, then I'm good to go. It's not that easy. It's not that simple. And the main reason that we're here is to tell you, you've got to take active moves to protect those rights in your intellectual property. So yeah, let's get to it.
And I mean, quite frankly, right? Like we also like to believe that people are going to operate with integrity and not going to just take your stuff, right? But the reality is, and we see this a lot, people will share their ideas. They'll share their business names and their slogans and their mottos with people before they've even put them out there. And next thing you know, somebody swooped in, filed a trademark application. You shared, something that you wrote with someone or an idea similar to it. And then they go and file for copyright registration and it just becomes a mess, right? So to Shannon's point, it's important that you understand being proactive. And I know I say this all the time, being proactive is the key, right? When you're running a business and when you're trying to protect your business. So you want to be on the front end, making sure you protect your business and your brand versus having to be on defense and try to undo somebody's whatever plagiarism, copying, whatever you want to call it after the fact. It costs way more money. It's way more time consuming. It's a lot more draining. And we need to stay ahead of the game. So, so yeah, that's what we're here for. So let's talk about, we know that there are a few different ways that you can protect your brand, right? The main ways are through copyrights, through trademarks, and of course, through patents. So today we're going to go a little bit deeper into copyrights and trademarks. Next week, we'll be having a talk about patents that'll be a lot more detailed with one of our patent attorneys. But today we're going to focus on copyrights, trademarks, and how to protect those things and to just be smart about the moves that you're making so that all of your hard work and your dedication and your visions, right, are protected. So let's talk about copyrights. So when it comes to copyright, Shannon, you want to give them a summary of a copyright. When do you copyright? What is the purpose of a copyright?
Okay, so like I was saying before, the things that we talk about in intellectual property are they have these sort of simple sayings that go with them, and then we sort of kind of explain it out. So for me, simply put, a copyright is your right to copy. And oftentimes we don't pay attention to that. It is your right to copy. It's your right to distribute. It's your right to make photocopies if it happens to be a photo, if it happens to be a sculpture that you've taken a photo of. If it's a writing. So what it really is definitionally, a copyright is any original work of authorship fixed to a tangible medium of expression. And the way that we sort of explain that outside in layman's terms is it's something that you created, you originally created. That's what we call it, intellectual property. It came from you. Right. And you're able to allow someone else to experience it. So someone else can hear it, they can see it, they can feel it. They've got to be able to experience it. It can't just be your idea. You can't just have an idea and say, well, you know what? I can actually register that idea for copyright if you've not fixed it to anything. You can't sue someone for using your material if you haven't fixed it in a way that they're able to see it, to use it, to experience it. And so copyright, the right actually fixes it actually applies as soon as you fix it. As soon as you write it down, if you're writing a song, if you're writing a poem, if you're writing a book, play, anything of that sort, as soon as you record it for those recorded works, those musical works. And then again, as soon as, if you're creating a sculpture, if it's an architectural design, as soon as you put it in something that someone can experience, then the right attaches. However, if you do not register that work, then you can't sue anyone for infringing upon the work. You can't sue someone for stealing it, for copying it. You can't, and also, you can't prove that you're the one who has the right to copy. I'm gonna let you chime in on that, Marissa.
Good stuff. So, and that's all of that. Your example was actually really good because I'd never thought about it like that. Just it being your right to copy, right? So when we're talking about copyrights, just to clarify, what she's saying is that as soon as you create something, you own the copyright to that, right? Similar to trademark. As soon as you create your company, if someone else hasn't already been using it, then it's yours. The key here is that in order to enforce that right, you have to register your copyright. So just to, expand on the different things you might need a copyright for, because we often think, books, right? We think poems, we think things that are written, but there's so many other things that could also be copywritten. So any artwork, plays, scripts, film that you've, videoed yourself, choreography, dramatic works, sound recordings, all of that stuff. There's so many different things. So anything that you've created can be copywritten, but it goes well beyond just the stuff that's written down, right? So anything you want to add to that?
Yeah, I think that often, and the reason that we're explaining it is because there is a difference, a marked difference in copyright and trademark. So it's important that you understand that the things that you are submitting for copyright registration are the things that you want, again, to be able to copy and distribute, or to manage whether or not someone else can copy and distribute it. And so when you're thinking about, is this something that I need to submit for copyright registration, the thought should be, is this something that can be distributed? Is this something that can be copied in some sort of way? Is this something that someone can create a work, something else based on what they see? Then you can determine whether or not, you can think about whether or not that's something, a work that should be submitted for copyright registration. And
right.
She said, a lot of people think about, songs, poems, and things of that sort. But yeah, a sculpture is an artistic work that can be submitted for copyright registration. And not even just a sculpture, any sort of design like that is an artistic design, not necessarily a design for function, but an artistic design can be submitted for copyright registration as well.
Right. So in other words, if you out here creating something in these streets, you need to make sure that you are taking the steps that are necessary to protect that stuff, right? Because you don't want to end up in a situation where, somebody went to your website and downloaded your stuff and they're sharing it for charge, right? Because people do that. You might have, for example, if you create a course of some sort, an online course, you're giving people, selling people the right to access that course, all of the information contained in that course, your images, your notes, your thoughts, your advice, all of that stuff in a course. And what I've seen before, I've had to deal with this with one of my clients before, somebody who was a participant of the course, right? They paid to participate in the course, but what did they do? They were also a coach, and they decided to duplicate that course. So they took all the content, they saved it, right? They basically recreated it the exact same way. They changed some coloring. They changed the fonts, maybe. They might have added a little bit, of their logo, their branding to it. But essentially, it was the exact same course. And they took that and they started to sell it for cheaper, right? So then people are like, oh, well, I can get this course over here. Same name. I think they changed it just a little bit, right? So they were able to sell it, and they were making money off of it. My client had no idea until someone realized, hey, this looks a little similar to something I've seen before. And then we had to jump in there. But again, at that point, that particular client didn't have her stuff registered. So then it goes to, now we got to rush to get stuff registered. We got to wait on the copyright office to deal with that. And then on top of that, we have to start to proceed to try to enforce it. And again, too much time, too much money, too much headache. So
The thing about that too is, so in copyright, you can have a derivative work, which is a work that's derived from that original work. And what oftentimes people do is, so that they can still have the opportunity to steal your work, they'll try to make little changes. They'll try to have some nuances. They'll, like she said, change a color, change, something so that it's not the exact same. So I didn't infringe on the work because it's not the exact same. It's still infringement when you create a work derived from a work that already has a copyright attached to it. And so what she's saying about this client is the person infringed on that client's work because, as we said, copyright attaches immediately, but she couldn't do anything about it. He or she couldn't do anything about it unless and until they registered the work with the U.S. Copyright Office and then tried to enforce. But by that time, someone's already making a great deal of money off of something that you created.
Right. And then we got to backtrack and try to determine how much money has been made, how much of it was solely because it was the work that was copied and not something. It's just a lot. Y'all don't want to have to deal with that. More importantly, most people don't want to have to pay for that to be dealt with. Right. So just know that, handling that type of stuff is extremely important. I know I sound like a robot because I keep saying that over and over and over, but people, they don't realize it. You don't really realize how important it is until you have to experience it. And then when you have to experience it, it's just too much. It's a headache. And we prefer not to have to do that. So anything else people need to know? Oh, let me tell you. Another thing about your copyrights is, and this applies to trademarks as well, but it's your responsibility to basically police your work, right? So when you create something, you are the one that has to monitor what's going on, monitor to find out if people are using it, and it's your responsibility. The Copyright Office isn't going to call you and say, hey, notice that somebody's using your play that you wrote. That's not really how it works. So one thing that I like to share as just a tool to use is a site called Copyscape. I don't know if it's .com or .org. Do you know, Shannon?
Or give me 1 second.
Okay, so it's Copyscape. I think it's .com, but essentially it's a website that you can go to and you type your web address in it wherever your content. And this is specifically for content that's online, right? So you go to your site, to this site, you type in your web address or the web address of whatever site it is that you want to monitor or see if there's something on there. And there's a free version and a paid version. Start with the free version, is better than nothing, right? So you type it in, it essentially scans the internet to see if there's any language on any other site that's similar to yours or exactly the same, right? So the first time I went on this site was a couple years ago, and I just typed my law firm site in, right? Because I have a bunch of blog posts and things like that on my site. So I go on there and I type my web address in there, and I discovered that there were two lawyers, yes, lawyers, who essentially cut and paste my blog post onto their websites. And they were acting as though they had written it. It was my voice, because my voice is pretty distinct. I don't write like most lawyers do for the most part, right? So it was my stuff, and they literally just cut and paste and put it on their site, right? And it was like, y'all are officers of the court, right? And this is what they were doing. One of them indicated she didn't realize that it was considered copying because she was adding, at that point she hadn't added it yet, but she was adding credit at the end. And we'll talk about adding credit and giving people credit for their work. The other person said that their, I think, virtual assistant, and this is a common excuse, their virtual assistant must have done it. They didn't know anything about it. But the point is, if you have lawyers, right, that are copying stuff and stealing, essentially, don't for a second think that someone who is not, clear or abreast on the law isn't going to copy, because people do it all the time. So when I learned that people were copying me, people that do what I do, I was like, okay, this mess is real. So,
and you know what? And the thing about that is, I think it's really important in the practice of law. Oftentimes, and Marissa can attest to this, we usually get into some things with law that we've had personal experience with, right? So we become a lot better in our jobs because we've seen this before in our own lives. We want to make sure that our clients don't see the same things that we've seen. I've had music taken from me, copied, and put on someone else's album when I was a child. I've had a project that I created when I was a teacher be used by another teacher who essentially claimed it as her own. And when you don't protect yourself at the outset, you either lose out or you start fighting, and by the time you win, is the win even worth it? You know what I'm saying? And so it's important that, I mean, we're saying this to you because we've seen it. We know it, we've seen it, experienced it firsthand, and then we see it over and over again with our clients who come to us after the fact saying, I had this great thing, I did a great thing, and someone took it from me. And our goal is to help you so that someone doesn't take it from you, and that also you're able to utilize. You're the one who's supposed to be able to exploit, manipulate, allow someone else to use your work. It shouldn't be the other way around. Somebody shouldn't just be doing it and then you've got to now get to them and say, hey, you know, that's mine, right? It shouldn't be like that.
Right. Absolutely. So what about stuff that, like, is everything copyrightable? Can you think of some things that we can share that are not copyrightable, so to speak, commonly? I know that names and titles and ideas, like you said before, are not copyrightable. Anything else you can think of?
The main thing with the names, titles, which can include, like, people try to copyright things like countries. And I mean, you can't do that. You can't just copyright certain words and phrases just because you say, well, I came up with this word and I came up with this phrase. And that's why we get into the whole idea of the trademark, right? But there are those types of things. No, you can't submit for copyright registration. They're not original works of authorship. They're not something that you created out of your mind. Sometimes you may think of how to put certain things together. Like, for instance, a recipe. It does not make it doesn't make sense whatsoever to submit a recipe for copyright registration. That's in my opinion. And Marissa, you can tell me if you feel any different about that. But because oftentimes the whole point of the recipe, the whole reason that you created a recipe is to keep it, and you want to monetize it, is to keep it a secret. So when you submit certain things and they come out in the public, then you're kind of positioning yourself to hurt your brand instead of help your brand.
Right. I agree. And recipes is another one of those tricky ones, because I do know some people have copywritten. So you can't copyright the actual recipe. But if there are things, especially if it's basic stuff. So let's talk about like Pinterest. You go on Pinterest, there are thousands of recipes, and then you change one ingredient, right? And now it's a new recipe. And then you add another something, and now it's another recipe. So when it comes to the recipe lane, it, again, like Shannon said, for the most part, it doesn't really make sense. But there are some people who have been able to secure copyrights for certain types of recipes that are a lot more involved. And it has to be something that is extremely unique, so to speak, as far as the processes and things like that when it comes to recipes. But yeah, the point, most people share recipes because they want people to make their stuff. So someone
asked a question though.
Okay. I got a bunch of questions in here, so I don't know if you want to just jump in on some of them now before we move to trademark. Okay. Okay. Let me see if this is the same. Oh, that's a long one. No, that's trademark. Hold on. I'm gonna wait for the trademark question. Nope. All of the an event title. An event title is a trademark or copyright registration. You want to answer?
So I'll take that one on. We just mentioned about names and titles and things of that sort. So here's the deal with an event title. If you have an event that you've created, and the goal of the event is, at least the goal of the title is so that people know who's putting on that event, then it is not something that you submit for copyright registration. It's not an original work of authorship fixed to a tangible medium. It is a mark that you want to use in trade. It's a mark that you want to use to be able to receive monies for the event, and you want people to know the event by the mark. So no, it's not something, it's not a trade, it's not a copyright. It is something that I would say you submit for trademark registration.
Right. Now, someone asked, what was the name of the site for policing online content? I'm going to put that in the comments right now. And let me just pop it on the screen really quick. It is copyscape.com. So again, they have a free version and a paid version. But just test it out. Test out the free version just to see what comes up. You'll be surprised. You might be surprised to see that there are some sites. Now, sometimes it will pick up a site that just has some stuff that's like standard language, like a definition or something like that. But for the most part, it's pretty good at scanning and finding full-blown plagiarized content. And I know my son's teacher the other day, she was using some other site. I don't know the name of it. I need to find out. But she was using some site to scan for plagiarized work when it came to his assignments. And there was one particular assignment that I saw. She said that she was like, this article or whatever it was he wrote has 32% of something that I found on the internet. And I'm like, how does this lady know the percentage? But it was because she used a program like that to scan the internet to find out it was, copied. So definitely check out copyscape.com. And if you know any other sites, feel free to share those in the comments as well. But yeah, that's a good place to start for sure.
Can we answer Deborah's question? Or maybe her comment? Let's she has a comment on that I want to discuss.
Okay. Which one? Hold on.
Her PSA videos.
Oh, okay. So PSA videos.
Yeah.
So for those of you that don't know, Deborah is one of our attorneys on our team, and she actually does these perfect public service announcement videos that she launches every week, right? And she talks about all kind of stuff. They're comedic, they're hilarious, but they're also informative, right? So
they are videos. Great videos.
So the PSA, Shannon, copyright, trademark, what we doing?
So the PSA, I would submit the PSA for copyright registration. The reason being is because we mentioned before, it's a dramatic work, right? Yeah, you're being informative, but you're giving everybody life with those PSA videos. So you've got a dramatic work, right? You've got a sound recording, right? You've got so many different things with regards to those PSA videos. The copy, the actual words that you put in those PSA videos can be sent for copyright registration. It's an original work of authorship. You've created it. It came from your experience and you fixed it to a tangible medium and have done that and you're able to do that in a few different ways. So you've got something that, it's great and it should be submitted for copyright registration.
Totally agree. All right. Anything else we need to cover for copyrights? I know that let's talk about the fair use doctrine, right? Because I know that you touched on it a little bit before, how people will want to use some work of someone else, right? Like, is every time someone copies or takes your work and puts it somewhere, is it always considered copyright infringement, or is it fair use essentially?
So the major thing with regards to fair use, which a lot of people don't necessarily know what fair use is. So ultimately, one of the biggest things we look at with regards to infringement, and one of the biggest ways we're able to stop infringement, is because people they're copying your work and they're using it for gain, for financial gain. So oftentimes there is, well, not oftentimes, but there is a doctrine that allows you to use certain works for other reasons, and it doesn't include financial gain. So if it's a parody, which essentially, if you've got a dramatic work and somebody is literally making fun of that dramatic work, they're allowed to do that. It is fair use for them to make fun of your work. If you have a work and that work is being used for an educational purpose, you are allowed to use the work for an educational purpose. Now, let me make a note on that, because oftentimes, and what people don't understand is that when you cover someone's song, you are still infringing upon their copyright. And oftentimes people think, well, how am I infringing on a copyright if I'm doing it and I'm not making any monies? Because there is that, if it's for a charitable reason, then you kind of have that opportunity to be able to use the work. The big thing is that you are publicly performing someone else's work. And when you're publicly performing it, you're copying, quote unquote, the performance. And that cover, right, is copyright infringement. And a lot of people want to claim fair use because they're saying, well, it's I'm not getting any money from it, or it's a parody, but they're not really making fun of the work. They just want to use it in a different way. They just and so people try to come up with these creative ways to be able to use someone else's work, to copy someone else's work. So it's important that we know that. And I'm a musician. I sing all the time, and I sing other people's songs all the time. We do it in church. So when we're having praise and worship, we're in a charitable organization. We're actually allowed, when we're having praise and worship, to sort of sing, those songs. But then on the flip side, if you are out at a club and you just decide to jump up there and perform someone's work, it's infringement.
Right. And that's the reason why you have radio stations and clubs that purchase licenses to use that music, right? And that's also the reason, like, if you look on Facebook and somebody's playing some music on their live video, right? People put that disclaimer at the top: I do not own the rights to this music. This is not infringement, because it technically could be. And technically, there are a lot of times and instances, and some of the production companies or whoever owns the music are a lot more strict than others, right? Like, if you upload a certain video on YouTube, there are some companies or owners of music who will literally have your stuff taken down within 30 seconds. Like, they already have it set up with YouTube or whatever sites, Vimeo, whatever, that automatically flag the use of their music. So even for me, when I'm posting stuff on YouTube, my videos, even my intro songs and things like that, I always make sure that I have the license to to share that music and use it in my videos for commercial purposes, or even just for personal use, because I'm putting it on the online in public, and I ain't trying to be a part of nobody's lawsuit.
Nobody has time for that. And
right.
Really, I mean, you got to think about DJs also that are playing music, and especially because we're having this time where we're able to jump online and party and club, right? And we're hearing these DJs. Oh, they have to have licenses for the music that they're playing, because they're publicly. It's that public performance of a work that has already been submitted for copyright registration, and you cannot infringe upon someone's work.
Right. And thankfully, most of the DJs already have that stuff done, right? Like, they've already secured their licenses because that's what they do all day, every day. So they have purchased, blanket licenses and things like that allow them to play their music in these spaces. But then you have some people who might not be a DJ, right? Like, I might just want to get on and play some of my favorite songs. Am I going to be able to do that like, DJ D Nice? Probably not, not without an issue. So shout out to D Nice, because his club quarantine has been the business lately.
Oh, good, right?
but yeah, so you just got to make sure that you're careful if you're using somebody else's work. So another way that you can use someone else's work is, for example, in the news, right? So you'll see someone post a video of something that happened, some foolishness usually, right? And then they put their commentary with it, like, can you believe this is going on? That would be considered fair use under the fair use doctrine. Reviews, posting something for the purpose of reviewing it, whether it be, a product, a service, or a course or whatever. If you're talking about it for that purpose, that could also be considered fair use, as well as criticism. And also research. If you're using someone's whatever it is for research purposes, that kind of falls in line with the educational purpose piece. So you have some leeway, but again, just make sure that at minimum, what you can and cannot do, so that you can handle that. So let me go in here and answer a couple more questions. I see Deborah is asking, is it going to be expensive? So let's talk about the cost to copyright, right? The filing fee is pretty low compared to trademarks. What is the filing fee? Like $35 right now? Something like
35 that? And then $55 for certain types of registration.
So when it comes to comparison of trademark filings versus copyright filings, the price difference is substantial, essentially, right? So it's not as expensive as it'll be to try to litigate it after the fact. I can tell you that. So when it comes to filing your copyrights, no, I'd say it's not considered expensive when you look at other things that would come to the forefront if you have to try to defend your case and all of that stuff. So copyrights, I think, are fairly inexpensive. Now, another way is that you can also, for certain things, you can copyright collections, right? Instead of individual things. So for example, blog posts, for example, sometimes I copyright or register my copyrights for a blog collection, right? So all of my family law posts for 1 quarter, I'll put them to be copyrighted as one collection. Then I only have to pay one fee for that. The same
Right.
goes for, a book. Obviously, you want to copyright the entire book. If you have a photo collection, if you're a photographer, I think, Deborah, you probably could put, a substantial number of your PSAs into one collection for copyright purposes. And, so if you have multiple things that are similar, right, or the same, but maybe a different topic or things like that, you might be able to, do a collection instead. You got anything on that?
And real quick, the registration is actually it's $45 for the electronic registration, and then so it's bumped up to 45, and it's bumped up to 50 to 65. I'm sorry, if it's not. So the electronic registration is going to be a work with one author, right? A work that's not a work made for hire, meaning you didn't commission that work. And so we didn't talk about works made for hire, but a work made for hire is one where you hire someone to create a work. You aren't necessarily the author. It didn't come from your mind as far as writing it down or drawing it or creating the sculpture or the architectural work, but you hire someone to create it for you. And it could be based on your idea, or again, you commissioned that work and gave them creative license to create it for you. Now, if you are submitting a work for hire for registration, you're going to pay a $65 fee instead of that $45 fee. But if it's one author, and it's not a work made for hire, and it's not like a compound work where she was talking about the collection of works, then it's the $45.
And since we're talking about works made for hire, and we're going to move on to trademark shortly, but I just want to jump in on the works made for hire, because that is another issue that I personally deal with, for my clients on the regular, because a lot of times people will hire people like an illustrator, for example, or a writer, a ghostwriter, or whatever the case may be. And there's always some confusion as to who owns the rights to what, right? Who is it really a work for hire, or are they an employee, or, how is it going to work? So my general, suggestion is make sure that whoever is going to own that work is outlined in the contract that you better have.
Yes.
And I know most of y'all ain't got no contracts, because
you better have one.
You come after the fact, like, oh, I drew this or I wrote this for so-and-so, and now they're using it on everything and making thousands of dollars a month from it. Well, who owns the work? Right. And so that's a whole nother conversation for a whole nother day. And maybe we'll talk about that next week on our business series. But you guys have to make sure that, one, if you're doing this work, or if you're paying someone to do the work, there needs to be a very clear outline of who is going to own the work when this is all said and done, and who's going to have the rights to use it in any fashion, right? So if, for example, you're doing something for someone, can they use that? Can the artist, the original artist or the original creator that you hire to do whatever it is, can they then use it for reviews or in their portfolio, right? Photographers, if I'm taking photos of your family, I might want to use those photos in my portfolio. Can I do that?
I want you to. And that's the big thing. So a lot of people, and let's just be real, a lot of people are doing boudoir photos, right? You're getting these husband and wife, or friend and friend, wife and wife, whatever you are. You might be getting the nudes and all that. And I'm saying that because you've got a photographer taking photos of you. They're going to upload those photos, and that photographer owns the copyright to those photos, unless you have a work for hire agreement that says, I own every one of those photos. I own every file, and I don't want you to ever use that for your own personal use, gain, or even distribute it to anyone else. And if it's not outlined in your agreement with that person, you just had somebody take photos of you and they can do whatever they want with it, because it doesn't belong to you. It belongs to them. Now, we can get into privacy laws and all of that, but what it is someone created a work, and that work came from their camera, their lens, their eyes, and they own it. They own the copyright to it, unless it's a work made for hire, and then you are able to own that copyright.
Right. And speaking of that, another issue that comes up is, for example, with photographers. I know this has been an issue, and I had this issue before. When you hire a photographer, right? A lot of photographers will give you, some photographers will give you all of the photos that were taken. Other photographers will allow you to choose a certain number of photos that were taken, and those are the only ones that you get to use. So you can't use the ones that were, considered proofs that you didn't approve or that you didn't select. So you also got to be careful when you're hiring photographers and selecting them, because depending on the project and depending on how you want to be able to use this stuff, you might not even be able to do it. And if you pay a photographer $400 and something, right, to come and shoot you for however long, you might want to be able to use all of those photos in your social media and for marketing and for other things, and then just use the ones that they edit for like publications and major things. All photographers don't allow that. So you got to make sure that there's that understanding. And again, them contracts, they come in handy, boy.
Yes, they do. They definitely come, because I will tell you, my photographer has the right to use the photos that he takes of me for his advertising, for his business. So I'll see my photos pop up randomly, and I'm just like, oh, okay. And it doesn't bother me, because I already understand that is the relationship, the agreement that we have between each other. When you don't understand that, and you find that your photo is up on someone's website because they want to show their work, or it's used in someone's flyer, again, because they want to advertise their work, then you can't do anything about it, because you've not contracted for something different, and you've not protected what could be your right in that work if it's something you commission someone to do.
Right. And then on that note, I remember I had one client who had an event of some sort, and a photographer came, they took photos, and there was an event planner or something there. And I remember very clearly there was an issue with, I believe the photographer might have also been one of the joint event planners, but they didn't participate fully in that piece. But the issue was the photographer who had taken those photos was promoting his business as an event planner, right? So people are calling the client like, hey, you used him for an event planner. And she's like, nope, that's not what I used him for. But because he had all those photos, right, he's going to use them however he wanted to. So that again comes down to the contracts and what it says. If they're going to be allowed to use them, for what purpose, right? So in my contracts with my photographer, typically it says that you can use it, but you're not about to just be posting any old photos of me that I haven't approved.
Right.
If I didn't select them, specifically, I don't want them up there. You got to take some notes from Beyonce, right? Like Beyonce, you ain't posting no photos of Beyonce without her team sending you some messages like, hey, you need to take that down. She didn't approve that photo, right? If it's one that captures her in a light that is not her thing, she's like, nope, take it down. And people, they take them down, right? So you just got to have the understanding. Again, you want to make sure that it's clear what's supposed to happen. So let me take a question here. Should podcasters obtain digital music licenses from all four pros for music they use? You want to take that, musician lady?
I think it's the same as what we kind of said before. If you're going to be using someone's music, you need to get licenses, period. And it's that easy. You need to reach out and find out who you need to speak with, what the dollar amount is going to be for the licensing, and make sure that you keep record of the licenses that you have, so that you don't find that, because here's the deal, we're human, and we try to put everything, always submit everything into our digital platforms, submit everything into our case management, and things slip through the cracks. So if you don't keep your own records, you can still position yourself for someone to come after you for copyright infringement, even if you purchased licenses. So just be very careful. But I do believe that it's important that if you're going to be utilizing someone's music, then you utilize it with a license.
Right. And here's another question. That's why we have photo or video release forms. Let me tell you about them forms. Make sure you read them. right? It's so easy. And this happens all the time. You go to a photo shoot, you show up on set, you sign the release because they say, here, sign this release. People
Mm-hmm.
don't necessarily read them. And sometimes these releases be something else, right? So you need to make sure
Yeah.
you know what you're signing. Again, another conversation another day that we're going to have about these contracts that y'all signing without reading them and then want us to fix the problem after the fact.
Oh no, I didn't even read it.
Right. I
That's
didn't read
why
it.
we're here.
Yeah, you gotta read it. If you signing stuff, read it, because if something goes down at the end of the day, right? Like even during this quarantine right now, we're in quarantine, and so many people have contracts, and this is something we'll be talking about next week with Attorney Shannon. But so many people have all these contracts in place, and they can't fulfill the terms of the contract because of these stay-at-home orders, or whatever is in place, or they simply don't want to, or all kinds of stuff. So you gotta know what's in your agreements. And now people are being, now we're realizing the importance of knowing what's in there, but also knowing what's not in there and knowing what should be in there, right? So now, as we're moving forward, more people are going to have force majeure clauses in their contracts that they didn't have in them before, because they didn't think, oh, ain't no catastrophe gonna come through. No act of God is going to come through and cause me to be out of business, right? So I don't need that in my
And they're going to
contract.
beef up their termination clauses, and they're going to beef up those force majeure clauses
Yep.
because we're looking at people who are oftentimes you're creating agreements, off of the internet using a Google Law degree. And what ends up happening is they come back to bite you. And so a lot of people are about to be positioned a lot different. And we've got, like she said, it's another conversation for another day, because we still have to get the trademarks and try to give you guys some information on that.
Yeah, so let's go ahead and move on to trademarks, because we can literally go on about copyrights and the issues that come up, because it's one of those subjects that's so tricky, because everybody owns their copyrights, but you don't really, understand how it can be used. And there's so many nuances in between, right? So many exceptions. So moving on to trademarks, let's just talk about trademarks. You want to talk about what exactly is a trademark, and when do I need a trademark?
All right. So a trademark is just like I said, a copyright has that simple, your right to copy. A trademark is your mark in trade. And so what it essentially means is it's a word, a symbol, a phrase, some sort of device, something that you use specifically for people to know that it's your goods and or services being sold. So they need to be able to understand that the source of the goods and or services is you. And when we say in trade, what we're saying is that you're actually selling that product and or service. What I tell people is, and then let me tell you, so we've got people that will submit a trademark. We have two ways to submit trademarks. One, and these are federal trademarks so that you understand. I practice in the state of Florida. In the state of Florida, you cannot submit a trademark application unless the mark is already in use. And I'm going to say that again. In Florida, if you're just doing a local trademark application, you cannot submit that application unless the mark that you want people to recognize your goods and or services by is already in use. Federally, if there is a mark that you intend to use for your goods and or services to be recognized, then you can submit an intent to use application, and or you can submit an application when, again, that mark is already in use. I tell people to submit a mark for trademark registration when you're married to it and you're ready to press go. You're ready to use it. It doesn't have to already be in use, but as long as you're married to that mark, you need to be getting with someone to submit a trademark application. And the reason I say be married to it is because, and I like the concept of you got to date me before you marry me. You need to date that mark before you marry it and before you submit it, because especially us women, I changed my hair. I changed my hair color. I like to use the different types of accessories, right? So we switch it up so much.
Right.
And what ends up happening is you submit a mark, you could get that mark registered, and then you don't use it. So now you've abandoned your trademark. So you need to be married to the mark. You need to, and plus, beyond being married to it, and the idea that we can kind of change our minds and everything. The big thing about that is one, you don't want to abandon a mark, but you also don't want the rest of the world to look at you as not having a consistent brand. We're talking about brand protection. We're talking about people knowing who you are and what you do based off of your brand as a whole. And so when you submit a mark for trademark registration and you're married to that mark, it's a mark you intend to use for the long haul. And it's not to say you can't add other trademarks into your brand, but you certainly don't want to submit a mark that you intend or that you may abandon in the next couple months because, it's a lipstick change.
Right. And that's a good point, because I've had some clients we literally file the trademark application. We get to the end. I get the certificate like, oh, I got the certificate. I'm about to send it to you. And then they're like, oh yeah, by the way, I changed the name. I'm going to need another trademark. And I'm like, bruh, you're killing me. Because now we got to start this process over. You got to pay these fees again, which I'm not going to complain. Right. But I don't want people wasting money either. Right. So just, and that go ahead.
I had a mark, a client submit a mark to me for registration, and it was an intent to use registration, meaning that particular client was not using the mark yet, didn't want to use the mark until we got the certificate of registration, right? So we get the notice of allowance, which is the U.S. Patent and Trademark Office allowing my client to use that mark, and then let the U.S. Patent and Trademark Office know I'm now using the mark. And when I got the specimen to prove that my client was actually using the mark, it was a different mark. And I was like, this don't look the same. And the client was like, well, don't you like the second one better? Of course, but we can't do anything with it on this application. Like, what can we do? So like I said, marry that mark before you submit. Listen, the application fee is a little more expensive than it is for copyright registration. So and that translates to your attorney fees being more as well. So if we have to switch that up and do it again, guess what? We're starting over, sir.
Yep. So speaking of the application for trademarks, well, first let's talk about what needs to be trademarked. So we know that we can trademark a name, right? The name of your company, the name of your brand. What else can we trademark? Slogans,
logos, and that's the main thing. It's going to be a slogan, a logo, a name, some sort of device that is used. Trade dress is essentially like a color, a specific color that you might be using, a specific way you might be using that color. And so those are the things that we can submit for trademark. But the main thing that we want to drive home to you is it's got to be that slogan, name, logo that is going to have someone know that your goods and or services, that those goods and or services that are sold to them come specifically from you. That's the whole reason. And that's what we look at when we're trying to determine, okay, should I submit this for trademark registration? And there are certain marks that we can't register simply because they're looking for certain things when we submit a mark for trademark registration.
Right. Yep. So that's right. And also when it comes to like books and things, I have a lot of people who call me and they're like, I need to trademark my book. So you can trademark a book series, right? If you have a title, for example, that you're using and you're creating series and series and series. For example, one I like to use as an example is the chicken of the soup for the soul. What is that? What is it?
Yeah.
Whatever it's called.
Chicken soup for the soul.
Yeah, them and like the Diary of a Kid and book series, Babysitter's Club. Babysitter's Club back in the day. All of those things, like those series are
the
things
Left Behind series. I just had to turn around and look at it.
Right. So you could, if you have a book series, then you can potentially trademark that actual series. I have several clients who have created series and that's just what they're known for, right? So if anyone were to come out with a title that was similar, it would create brand confusion because my clients have used that title over and over and over. And it also ties into the rest of the brand. You can't just come up with one book title and say, I want to trademark this title. And that's how you end up with situations where, you'll see one title from 10 different authors if you go on Amazon, right? And or even just switched up a little bit, it'll be title after title after title, and you'll think it's one particular author, but it's actually someone else because they have not created recognition to the point where it's trademarkable. Is trademarkable the word? Is that a word? Well, we're gonna use it as a word today if it's not a word.
Okay. It's a collective word.
Right. So it might not be trademarkable if it's not something that is, recognizable for your particular company, your product, your service, your brand. So that's just another note on, when it comes to creating actual trademarked things like a book series or something like that. Also, there is slogans. I want to talk. Oh, hashtags. Let's talk about hashtags because everybody wants to trademark hashtags. What's your thoughts on trademarking hashtags? Is it doable? Is it not doable?
So let me say that the thing about hashtags, because even I found that even when you submit a trademark for a logo or for a phrase, but that logo or phrase is attached to a hashtag, you might have issue, right? And the main reason is because those hashtags are these things that's discoverable that a lot of people use all the time. If you're the only one using a quote unquote hashtag, again, I mean, you've got to be careful with it because it's something that you're using for people to recognize your goods and or services. And you have to be able to show that you're using it in commerce. A lot of people don't use their hashtags necessarily in commerce. We might use it to tell people, to show people how to get to us, you know what I'm saying? And how to give information, but they're not always going to be on an ad. They're not always going to be attached to something that shows what we're selling. And that becomes an issue. Are you putting, hashtag, whatever the phrase you want to use on your tag for your clothing, right? Or are you just using the phrase on the tag for your clothing? And if you're just using the phrase and not the hashtag, the mark is different.
Right. And that's similar to, I've had some clients who have had trademarks, but with hashtags, but they've used it in that manner. Or even some people go as far as putting the hashtag on their, like making that a part of their brand, right? Their t-shirt line. If it hashtag whatever, because most of the time right now, people are building brands on social media, right? And when it comes to building a brand on social media, like you're sharing stuff, and what do? We use hashtags, right? So you might have to go as far as including it in your actual brand. And really quick,
if you want to make a trademark, you don't have a choice.
Right, exactly. And then when it comes to, since we're talking about, I just lost my thought.
I'm so sorry, because I know I cut you off. I'm sorry.
We were talking about hashtags, blah, blah, blah. I don't really know.
Like run it back.
Sidebar and segue into something else so that I can be clear. Another thing that can be trademarked is designs. And that's something that people don't really realize, right? That they can actually trademark. So when you have a product in particular that is related to a design, right? That could potentially be trademarked. And I'm not talking about creating a t-shirt with a slogan on the front. And that's what people contact me. T-shirt lines are hot right now, right? They're selling like hotcakes. They're easy to do. You got Teespring and all these other companies that make it super easy for anybody to own a t-shirt brand. The thing about t-shirts, and I want to address this because it is so common and it's one of the most common calls that I get. The thing about t-shirts, when you're trying to trademark a t-shirt, is what people call about, you got to understand that when you're trademarking something like apparel, you're not trademarking the design on the front. That's copyrights, right? You create the design, you put it on the shirt, that actual design becomes a copyright, and that's what you would register the copyright. But if you want that design or that name or that slogan or whatever it is to be something that represents your company, right? Then you have to trademark it as your brand name. So you're not trademarking the design on the front. You're going to trademark whatever is in the tag or whatever is on the hang tag and the packaging. So I like to use the example of like Nike. Now, Nike owns a million trademarks, but we're going to talk about the apparel line Nike, right? So Nike, you'll see in every last one of their shirts, in their tags, on their packaging, on their hang tags, you'll see the Nike logo and whatever their slogan is at that particular moment. Usually just do it. But you'll see the Nike trademark on the packaging and on the tags. That's what you need to think of when it comes to creating a t-shirt line and things like that, because that's what you're trademarking. So like Hanes, they're trademarking whatever's in the tag. You can put whatever designs you want on the front as long as they're original and they're not someone else's, right? But that's not what you're trademarking. So if you have a super dope slogan that you want to be on the front of a shirt, but you also want that to be the brand name, then you need to create a line called whatever that name is, and that's what you have to put on your packaging and in the tags of your actual product. So I hope that clears up that misconception and understanding, because people often think, you have all of these slogans that go on the front of shirts, and people take the slogans and put them on another shirt, and then another person will take the slogan. I can't think of any right now, but there's so many times you'll see 20 different shirts with the same slogan with just a different design, right? And it's because that design on the front is not trademarkable. So anything you want to add on that?
Well, just that, like she said, it needs to be a part of your brand if you're wanting to use that quote unquote design. So for instance, that has to be in your tag. It's got, in the inside tag, it's got to be on the tag that you're using, that they're scanning. It can't simply be what you use as a design that everybody sees. You know what I'm saying? The whole purpose of it is that people recognize recognize that work, recognize what you're selling. And oftentimes it's not even, so if it's not your logo or anything like that, and it's a series of words that you're using, you need to make sure those words are on your packaging. The way that we are able to show, you know what I'm saying, that you're using that mark in commerce is on your packaging, on your tags. You know what I'm saying? Simply just showing it as what she said, as far as it looking like a design, doesn't necessarily mean that that mark is going to pass for trademark registration.
Right. And the purpose of a trademark literally is to prevent brand confusion with another brand, right? Another brand, whether it be a service, whether it be a product, that's the purpose of a trademark. So that's how you have to think of it. We're not thinking about just a little design on your shirt, because anybody can do that. We're talking about the actual brand, the actual company. And that would be the difference, the main difference between a trademark and a copyright. So I'll give another example. Christian Louboutin, them red bottom shoes. He was in a battle for years trying to get the trademark for the red bottom shoes, right? Because that technically is a design. And when people see a red bottom shoe, whether it's a knockoff or a regular one, right? People are assuming that those are Louis Vuittons, because Louboutins, however you pronounce it, I don't buy them. So anyways, however you pronounce the shoe, the red bottoms, y'all know what I'm talking about. People buy the red bottoms or they buy the knockoff version, but people automatically assume, oh, they got the knockoffs or they got the Louboutins. They don't assume that it's any other brand, because his shoes all have that same design on them, right? And it's become so recognizable that if someone else were to create a shoe that's similar, specifically a heel that has a red bottom, you're going to assume that they're copying, right? Mm-hmm. So ultimately he prevailed in that lawsuit. But so now you can't create no pumps and put some red bottoms on them. I mean, you can, but it's not a good idea, because they'll probably come after you. It's similar to the LV for Louis Vuitton, how it's all around the product, the actual bags that are created, or the MKs for Michael Kors. And, those are designs, right? And it's just having that on your actual products. If you see somebody with an MK, what are you thinking? Oh, that's a Michael Kors bag. Or the Dooney and Burke bird, right? You assume that that's a Dooney. If you see somebody with an MH, you're going to look like, is that a knockoff Michael Kors? If it's the same font, because the brand is so recognizable. So that is the point of a trademark. And I hope that kind of cleared that up.
And let me say something really quickly too. It's not, and It's the specific goods and or services that you have to pay attention to, because she made a point about seeing, if you were to see an MH, right, on something instead of that MK, if you saw that on a bag, on a purse, then you would be like, that's a knockoff, right? If you see that same MH on a vehicle, then you just think that that might be a new type of car. It's not the same. You know what I'm saying? And because we don't know Michael Kors to be a car designer, right? Then it's someone can use the same exact mark for a different good if that good is not related. And so that's a big deal that you need to pay attention to. You're not, when you submit something for trademark registration, it is so that people recognize your specific goods and or services. And it can protect you to the extent that there are some that are related or some that you may end up getting into. But ultimately, it's about the goods and services that you're using or that you intend to use. So if you're submitting for a clothing line, and then you all of a sudden there's someone else who is a doctor who's using that brand, they're different and they can very likely use it.
Right. That's kind of like if you use like McDonald's, for an example.
You
associate McDonald's or Burger King with fast food, right? But if I have McDonald's lawn mowing, nobody's going to side eye me because nobody, it's just not, it's not that thing. But have it your way, right? If I got a pizza shop and I'm using have it your way, I'm probably going to side eye like, are they using Burger King slogan? And it's too close to home, even though two different types of food, right? Because as of right now, Burger King sell pizza. They probably will right soon because they sell tacos. But
I don't like
so, it's too close to home. So it's just, you just got to be really careful and know that you're not infringing on someone else's mark, and then know that whatever classifications you apply for, that's what you're going to be using it for. And if you want to expand, you got to add those classifications. Yeah. So let's talk about the cost of a trademark and the filing fees and the process. And I know we're over our time, but hey, this collective conversation is how it goes. So the trademark process. I'll tell you two things and I'll let Shannon tell you two things. The first thing is long as heck.
Okay.
So, right. Like, it's not going to be done. You don't register your trademark or file to register it and get it back next week. It doesn't work like that. So that's the first thing I like to tell people, because they call me at the last minute. I need to trademark right now. Well, that's not really how this works, but okay, we can start the process right now, but you're going to be waiting a minute, right? So if you got those ideas and stuff, and you're ready to push go, like Shannon said, and you're married to it, you want to act sooner than later. And the second is that it's not cheap. And that's just the reality. I'll let you chime in and then we can go back.
So what she's just said, and I just want to point that out, and I'll do my chime in, but I heard this saying a while ago and it stuck with me. You can only get 2 out of the 3 things you want. If you want it to be cheap and fast, it won't be done right. If you want it done right, it won't, you know what I'm saying? So hear that again. If you want it cheap and fast, it won't be done right. If you want it cheap and right, it won't be fast, right? If you want it fast and done right, it ain't going to be cheap.
Right.
It just is. You can only get 2 out of the 3. Cheap, fast, and done right. Make a decision.
9 times out of 10, cheap is not.
So just be But with so she mentioned that it's not going to be cheap. She also mentioned that the process is long. The other thing is, this is when you submit something for trademark registration, you have to understand that you're dealing with laws. Okay. And you're dealing with the possibility of getting that mark rejected for whatever reason. So we talked about the likelihood of confusion, but your mark could also be rejected because it's merely descriptive. So there are several reasons why your marks can be rejected. And you're going to have to do some research, or you're going to have to hire someone, the collective legal crisis and management firm, to do some research to make sure that someone else is not already using that mark, to look at what you're trying to use and make sure that it's not, like I said, merely descriptive. And what I mean by merely descriptive is, if you just say, if your trademark is best cupcakes, you're just describing that you have the best cupcakes. You can't submit that for trademark registration without getting it rejected. You've got to have a unique mark that that you can recognize your goods, your cupcakes from. So you got to be a little more creative than that. So one, there are several reasons why you can get it rejected, and you need to make sure that you understand we're dealing with a body of law. And the other thing is that there is a research component that I believe is important. And oftentimes people want to skip that step. And I will tell you, if you try to skip steps, then you're going to find that the process is longer and could become more expensive, because although we flat rate a lot for trademarks, if you decide that you wanted to skip steps that we've told you to take, and we end up having to take longer because we're going back and forth with an attorney that's on the other side telling us that they're rejecting your mark, that is going to become a more expensive and a longer process.
Right. And to speak to the length, one thing that you will probably want to know is that we file. So when you submit your trademark application, it takes a while before an attorney at the trademark office or that works for the trademark office gets assigned to your file, right?
3 months.
And then from there, that attorney then goes back and forth with us, depending on, you know, what any issues are, any questions they have, any clarification they need or whatever. So sometimes I'll talk to an attorney 10 times because they don't understand why I have filed this mark, and I have to break it down for them, right? This is not descriptive. This is how you how it's distinct from another mark. And this is especially true with marks that are unique to a certain culture, right? So look, we Black. So let's talk about like Black culture, right? There are certain things that we as Black people say that other people won't get, right? So if you are trademarking one of those sayings or slogans that are known within a community, right? So if you're using something like that and the trademark attorney doesn't look like you or understand our culture, they might say, I don't think you could trademark that. And then we have to go in and explain to them, actually we can, and this is why. We don't mean it this way, we mean it another way. And that's something that comes up a lot, specifically in, you know, marks that are culturally based, so to speak.
Yeah.
So yeah, the trademark process is long. I try to tell people 9-month minimum. Expect the possibility it could go 18 months or longer. It's going to depend on whether someone challenges your mark. It's going to depend on if there are any issues with the actual mark or the specimen that you submit, or, you know, any confusion with the sometimes I get the trademark attorneys assigned and they don't even know what's going on because they're new. So then I have to cite different laws and codes to them so that they can understand why the application should go through. So it's really just depends, and it's case by case. I have some that move real quick, right? I'll get the attorney assigned at month 2, and then we're done by month 4. It really is just going to be case by case, and I love those, but that's not.
It don't have
right. It don't. The majority of the time, it's dragging on. I'll submit a notice or a response to a notice to the attorney. It take them 3 months just to look at it, you know.
Yeah.
So yeah,
quite often too. I mean, I've only had I will tell you, there are more that take long than the ones that go through very quickly and very smoothly. And the reason is, and you all have to understand this, we are dealing with humans. And I like to mention that all the time because you need to understand we're dealing with humans who are interpreting the law as they see it. And we're also interpreting the law on your behalf. And so when we submit for you, we're already ready to make arguments on your behalf, but there is someone on the other side ready to make arguments against registration. And so it's important when dealing with people, and you're dealing with people who are different and have different interpretations. I might get a mark to go through to one examining attorney that if it got to another, would have never gone through, and vice versa. And it's simply because we are dealing with humans, and it's subject to interpretation, just as, you know, the court system is. So it's important that you have someone that's able to advocate on your behalf with regard to it. Some of them, and I've heard a lot of people say, well, you know, I did my trademark on my own and I did well with it. And I say, kudos to you. You know what I'm saying? Because it doesn't always happen that way. It's not always smooth sailing. It can be very difficult, and it could also have been done wrong. Now, if it was done right, great, but it could also be submitted wrong and not actually protect you.
Yeah. And speaking of DIYs, when it comes to trademarks, it's not impossible to do it yourself, right? Like people, I have some clients who have done some on their own, but then some marks may be a little bit more complicated. Sometimes, like Shannon said, there is an argument to be made. Sometimes you get that attorney on the other end. It's like, no. And then you're like, well, what do I do now? So you have to just understand it really is just going to depend. And if you can have an attorney do it, it's a good idea because one, the trademark process is expensive. So the filing fee is $225 to $275 per classification, right?
Mhm.
So if you're selling t-shirts and jewelry and you're teaching a course on how to make t-shirts and jewelry, those will be 3 different classes, right? So though I try to bundle as many classes, as many, I try to bundle my clients' marks into one realm as broad as possible. The reality is, if you're doing a lot, you might have to do more than one classification.
Yeah.
And or maybe just start with one, but know that you're going to have to move to add another one or, apply for another classification. You don't just own the rights to sell t-shirts and under a brand and then also to teach a course on it. That's not really how it works.
It's never going to happen like that.
Yeah. And also, I just want to make clear, y'all ain't got to hire us, but whoever you hire to do your trademarks, please make sure that they are trademark attorneys. I've had too many people who have worked with attorneys before who don't know trademark law or who aren't experienced. And I'm all for people jumping into new practice areas, right? But not at the expense of it costing our clients money. So you have a trademark that goes through, you have an office action that was never responded to. You have people who are, they submitted the application for the wrong classification, submitted the wrong specimen. Now you have to start over because a lot of times the trademark office doesn't allow you. There are some parts of the application that you can't amend. So if you don't get it right on the first time, you have to start over. They don't say, oh yeah, you can send us a new this. No, that's not how it works. So using those trademark companies that they aren't even lawyers, quite frankly, right? You have some of those companies that you can get to do your trademark for $200 or whatever it is. Go for it. I'd say you'd probably be better off doing it on your own if you're gonna, go the cheap route. Because if you're gonna pay someone to do it, it needs to be done right, and it needs to be done with someone who can and actually will advocate for you, like Shannon said. And it's been too many times I get a trademark application. I'm like, well, I know. I look at it and I'm like, I understand why that didn't get approved because you sell shoes and they put the classification was for purses. I mean, like what? So just be careful, man. Like out here, and that's with any kind of legal situation. I understand lawyers are expensive, right? That's why I decided to be one reason. And but it happens to be one, but the reality is, if you're paying for an attorney to do your work, if you're spending hundreds or thousands of dollars, you need to make sure that you know that it's somebody who's going to do it right, not your cousin that does criminal law, right? Or traffic ticket law, and wants to dabble in trademarks. And I say that about any area of law. Like, I don't do patents. Patent is not my ministry. I don't pretend like I do it. I have hired, another attorney to come onto our team to handle that. And that's what she does. That's her specialty. That's what she does. My hands are off, right? Because I recognize what I do and what I don't. So just understand that whatever attorney you're hiring for whatever, whether it's business, family law, criminal law, whatever, make sure that they do what they say they do. So you don't end up in, a worse situation than you were in to begin with. That was just a random sidebar rant that I just felt like having right now. So let me go to a couple of questions. I have here, let's see. Are you all able to accept clients out of the state of Florida? Great question.
Yeah.
Yes. So right now, well, when it comes to trademarks, that's a federal area of law. So we actually have clients all across the country when it comes to actual trademarks. Our business divisions, we handle contract negotiations, contract development, business formations, and things like that in multiple states. Right now, we have attorneys that are licensed in Florida, in Georgia, in New York, and I am in California, in the Los Angeles area, and we're steadily, interviewing people and adding more people to our team. So if we don't have someone already on our team, already in our, on the collective squad, right now it's 15 of us total. If we don't have someone in a particular area, we do have a very large network of attorneys that we can refer to that we actually trust. So, and we don't just refer to random people because y'all ain't about to be messing my name up out in these streets. But yeah, so yes, to answer your question, Shannon is in Florida and we take cases in Florida, but we take cases, for trademarks in particular, pretty much everywhere. So, let's see here. I had a question that came in earlier on one of our original posts, and it is, I don't have a business yet, but I have little catchphrases and slogans that I will be using when I finally launch my business, which is a motivational speaking, books, clothing with phrases, etc. Is it a good idea to trademark or copyright those ideas now? How do I find out that's question one. How do I find out if someone else is already using these ideas or catchphrases, which is question two. So you want to take one of those?
I think we kind of jumped into both of those, but the main thing about the mark, we already told you, if you're married to it, you go for it. But here's the deal. If you're married to it and you submit that mark for trademark registration, you better be ready to use it. Because even if you file, which I discussed, the intent to use application, essentially saying, I'm not yet using the mark, I haven't necessarily launched yet, but I intend to launch. If you file an intent to use application and say your notice of allowance, which is the U.S. Patent and Trademark Office's way of telling you you're now allowed to use it, if that notice of allowance comes back in 6 months, you've got 6 months from the date of the notice of allowance to be able to use the mark. You can extend, you can file a petition for an extension to allow you more time, but you want to be ready to use the mark. And so I would say, as long as you're ready to press go within the next 6 months, you can go ahead and file the intent to use application.
Right. And also just a note to that, because the intent to use does add a whole nother layer of issues potentially, right? Because while you're intending to use it, someone else may already be using it, right? And then if you didn't have a bona fide intent to use it and someone else is using it, and then they might try to block your application, you might have to try to block their application. And, though that there might be a precedent that says, well, they filed the intent to use first, so maybe they should be the ones, who get to use it. The reality is, if you didn't have a bona fide intent to use it and someone else is actually using it, it's possible that it could go the other way. So I like to tell people, get on your stuff. It don't take 6 months to create something. I mean, it do, but it don't. Right? Like, so if you're at the point where you're ready to file this application, and again, it's not cheap. I mean, $225 per classification is, if you got a lot of stuff going on, right? Like, it could get pretty costly. So if you're going to invest, once you're at that point where you're ready to invest in your business or your brand, then you definitely want to make sure that you're actually, using it so that you won't have any issues. So let me just put up here, when we're talking about how do you find out, I know that we talked about Copyscape as it relates to copyrights, but then we also have, when it comes to trademarks, a way that you search. Now, let me just tell you, the Trademark Office's site, I just put the link up there, or the website up there. They have a search feature on the Trademark Office's site, right? The issue with that is that it's not comprehensive. So one thing, if you don't hire an attorney to do anything else related to your trademark, you might want to hire them just to do a comprehensive search, because you might type in your name one way, right? What you're thinking of using in the trademark search bar, and nothing comes back. And you're like, oh, I'm cleared. But then if you type it in a variation, a different, one that sounds similar, you got 30 of them that are already registered. Say that again.
A translation, if you type it in, you have to understand that if you use a mark, and I'm just going to use something simple. We talked about those red bottom shoes, right? If you call it rojo bottom shoes or rojo bottom tomatoes, right? Guess what? It's still red bottom shoes.
Yep.
It's just a different language. And if you typed it in one way, it doesn't mean it's going to come back that other way if you don't know how to search for it in different language.
Right. And you have to, I mean, the searches that we do are pretty comprehensive. Like we have to think of, and we have to be very creative in searching for anything that could sound or be deemed similar, right? So we have to like literally use our creative minds and just try a whole bunch of different searches that could potentially come up. And even I, you know, being experienced in this for years, sometimes I'll file an application and I've done a comprehensive search, but the trademark attorney's search might reveal something that they think may be similar that I didn't even think of, right? And I'm like, then I got to make an argument as to why it's not that similar, mainly because I didn't think about it. But, you know, you have to be creative and know how to work the law in your favor and make arguments to support your registration. So you want to make sure that you have a comprehensive search done to minimize the possibility that you'll have, you know, issues and challenges. It still may happen, because, you know, again, it depends on the trademark attorney assigned.
Right.
And what they're flagging and what they're not flagging. And then people, like some people with their own brands, they police it. I said it's your responsibility to police your brand. Some people police their brand pretty hard, right? So I had one client, her trademark had like 5 words in it. There was one word in that application. And when it came to her application, the other brand challenged her trademark application because it had that one word in it, which delayed our process. And we had to deal with that issue because it had one word in it. And I'm just like, y'all are crazy, but we had to deal with it. So it happened.
Yeah.
You know,
what was the second part of the question? Or the second question?
The second part of the question. Oh, the second question was, how do you find out if somebody's using it?
Oh, okay. All right. And you said that. Okay.
Yeah. So any more questions? I don't see any more in the comments section. Oh, wait. Yeah, I do.
Are you able to retro a slogan?
Yeah. When you say retro, are you meaning file it retroactively? Is that what you mean?
To show it. Here's the deal. When you file a trademark, and just let me say what I'm thinking. If you're saying retroactively, you're essentially, if you file an application for trademark registration for a slogan that you've already been using, right? Then that is the most common way to file a trademark application, is to say, I've already been using this mark for a certain period of time. So there's nothing wrong with doing that, as long as, now here's the deal. Let me say something about it. You can be using a mark for a certain period of time. Someone else can be using that same mark and you didn't submit it for trademark registration. And when you wait and then submit for trademark registration, you can't stop them from using your mark. So it is important that you try to submit that trademark application as soon as possible, because it is possible that you lose the opportunity to stop someone else from using a mark if they're already using it, or stop them from using it in a specific geographic location. It all depends. And we'd have to review everything to be able to tell you whether or not we think you're going to run into some issues. But you can submit a mark that you've already been using, and if you've been using it for a long time. It's just important that you submit that mark for registration as soon as possible.
Yeah. And more often than not, for a lot of my clients, because I have some clients that have a lot of businesses and they just been running businesses for long periods of time, and they just never did that stuff, right? So then once they come on, they want us to handle everything. And I have one client, she's been using her mark since 1992 and just has never filed a trademark. And, you know, I mean, it's dope that she's been using it that long, and I think we're not gonna have any issues with it, but it was just something that never came to mind, or that she just did not prioritize before. So just try to, you know, stay on top of your stuff. Yeah. So anywho, we're at 1.5 hours. We usually chat for an hour.
Okay.
You guys have been awesome. We thank you for tuning in. Again, if you are watching the replay, please make sure that you share this with anyone in your network. I think I do see one more question. Let me go ahead and pop it here. If you have been in business for several years without trademarking it, the name, and someone years later trademarks it, can you fight it? Yeah, you can.
Absolutely. So, and that's what we're telling you. We're telling you that someone else can fight you, but yes. So when a mark is submitted, when an application is submitted and it goes through to a certain point in the process, it is published for opposition.
Mhm.
And what that essentially means is that there is a notice that's put out to the rest of the world that says this mark is about to be registered. You want to say something before we do it? And then you say, yeah, I want to say something before y'all do that. And oftentimes, when marks are registered, when they're, published for opposition, there are attorneys that sort of can get involved in the case to sort of see if you can have any sort of concurrent use, if you can have any sort of license with regards to the use of the mark, whereby some people agree that, like I said, maybe I won't use it in the same geographical area as you, or maybe I won't use it I will use it for these goods and services only and not those goods and services. So it's possible for you to be able to come to an agreement with someone else that might be using the mark. But yeah, somebody can fight it.
And that goes both ways. Even marks that have been registered all the way, there's still ways to challenge those marks if you just, kind of sat and didn't register yours, but you were using it before. So, it's a complex area of law. It's very specialized. But there are, we lawyers, so we can make an argument for anything, really. So, it really just depends on the facts. So again, thank you all for tuning in. For those of you who are new here, we are at The Collective Legal on all social media channels. We are hosting these conversations pretty much a few times a week as of right now while we're on quarantine. So yesterday we talked about money moves you can make to prepare for a recession. Today we're talking about protecting your brand. Tomorrow our chief of staff and communication strategist will be on and talking about how to maintain the sanity in your household during quarantine and beyond. And she hosted something similar a couple of weeks ago when the quarantines first started. People are still talking about how their households and their spouses and their kids are driving them crazy. So if you've been having any, issues and tension in your home, definitely make sure you tune into that. Next week, I know me and Shannon will be on talking about contractual obligations during quarantine, right? Is that what we're talking about? During COVID-19, the pandemic, something like that. Mm-hmm. And then we also have Dr. Glenna, who's one of our in-house therapists. She's going to be we're talking about co-parenting with a high conflict parent. And we're also going to have some business topics next week as well. So just make sure you're following us on all social media channels. Again, we're at The Collective Legal. Our website is www.thecollectivelcm. LCM is for legal and crisis management.com. If you have any topics you want us to cover, shoot us a DM, shoot us an email, submit a contact form. We do read all of them. And otherwise, we thank you all for tuning in. Again, sharing is caring. If you know someone who can use this information or who can use our services, please make sure that you share. And thank you for tuning in, and we'll see you next time.
Thank you.